the issue of marital rape, you know, whether it is there is a marital rape exemption, you know, and it has been abolished as far back as in the case of R versus R, you know, marital rape exemption was abolished, but that is in the UK under the English law. But in Nigeria here, there is no exemption to that. So far as a man and a woman are in marriage, it's a legal marriage. The man is not expected to be seeking fresh consent before having intercourse with the wife. Well, that is not good enough, I think. So there is need for the reform of rape law in that area. Are you following me?
Yes, sir.
Okay. So there's need for reform in that area. And well, women are also generally excluded from having capacity to commit rape, generally speaking. You know, but women can be liable as accessory before the fact for facilitating the commission of the offense. And that was what happened in the case of R versus Ram. You have the citation of R and Ram, 1813, Cox 09. The liability of the wife is that he assisted the husband to rape the housemaid by holding down the housemaid so that the husband can forcefully have intercourse with her. So it was held that she was liable as a principal in the second degree. So you also note that by virtue of Section 357 of the Criminal Code, it is only a woman that can be a victim of rape. By virtue of Section 357 of the Criminal Code, it is only a woman that can be a victim of rape. However, the import of the Violence Against Persons Prohibition Act, VAP Act of 2015, is that any gender can rape any gender, and the requirement of penal penetration has been jettisoned. The import of Violence Against Persons Prohibition Act 2015 is that any gender can now rape any gender, and that the requirement of penal penetration has been jettisoned. So Section 1 of VAP Act 2015 provides that a person commits the offense of rape if he or she intentionally penetrates the vagina, anus, or mouth of another person with any other part of his or her body or anything else. Are you following now? So according to VAP Act, any object, it doesn't need to be a penal penetration. Under VAP Act, you can use any object. You can use finger, you can use object. And it doesn't necessarily have to be the female genitalia. It can be, the penetration can be targeted towards the anus or mouth. Any orifice will suffice for rape. So you can see the differences, the developments in the VAP Act over the Criminal Code Act now. Okay? Then the VAP Act does not give special protection to, marital rape. It doesn't give protection to whether you are in marriage. Any man doesn't give protection to whether you are married. Unlike the Criminal Code that gives exemption to married couple. But the limitation of VAP Act is that it's a federal legislation. So it doesn't operate in the states. So criminal law of Lagos State now punishes assault involving penetration with life imprisonment. So it doesn't describe it as rape. The definition of rape in criminal law of Lagos State does not extend to assault involving penetration. It is more or less a semblance of Section 357 in that it's still talking about penal penetration. But assault involving penetration now, which doesn't necessarily mean to be sexual, penetration, any assault that involves penetration now will attract life imprisonment. But if it doesn't attract penetration, that is a different ballgame, punishable under Section 261. But Section 259 punishes assault involving penetration. So when we are talking about accused use of rape now, we are principally talking about what are the physical acts that are expected from a person before he can be guilty of the offense of rape. So the accused use is the unlawful carnal knowledge. The carnal knowledge, you must have a carnal knowledge, and the carnal knowledge must be unlawful. So what is carnal knowledge? Carnal knowledge is sexual intercourse, and this necessarily requires penetration. Carnal knowledge is sexual intercourse, and it necessarily requires penetration. So in R versus Kufi, 1960, WNLR, it was held that there cannot be rape without penetration. It was held that there cannot be rape without penetration. See Section 6 Criminal Code for a definition of carnal knowledge. So in Ezigbo versus State, 2012, 5-7, MGSC, in Ezigbo versus State, 2012, 5-7, MGSC, Part 2, medical evidence of broken hymen was held to be sufficient evidence of penetration, broken hymen. So if the hymen is broken, it suffices to establish that there was penetration.
Hello, sir. Please, sir, before you mentioned Ezigbo and State, I think you mentioned a section of the criminal code, sir. I did not get that, sir.
For the definition of carnal knowledge, Section 6 Criminal Code.
Thank you, sir.
Definition of carnal knowledge. Okay, so the question that generated a lot of controversies in the past is how far a man's penis must have gone towards the female genitalia before penetration can be said to have taken place. How far a man's penis must have gone inwards the female genitalia before penetration can be said to have taken place. According to Professor Adeyemi, he posited that the penis must have left the orifice, that's the vulva. The penis must have left the orifice, that's the vulva, called the labia majora. Vulva, that is called labia majora, and must have attained lower region called the labia minora. Must have attained the lower region across the wall, within the wall of the vagina. There is the upper region, which is outer. That's the major labia majora, and the inner down along the walls is the labia minora. So the penis must have passed the orifice and must be about to touch, the inner one before you can say that penetration has taken place. However, the modern position is that the slightest penetration suffices. However, the modern position is that the slightest penetration suffices. So it is immaterial now whether the hymen is broken or not, so far as there is contact of the penis with the vulva. Whether the hymen is broken or not, penetration has taken place. That's the modern position of the law. So it doesn't matter whether hymen is broken or whether the ejaculation has taken place or not. It is immaterial. So mere contact with the vulva or orifice suffices. And on this, you see the case of Ogunbayo versus State. Ogunbayo versus State, 2007, 8 Nigerian Weekly Law Report, 157. Ogunbayo versus State, 2007, 8 Nigerian Weekly Law Report at 157. See also Section 258(4) of the Criminal Law of Lagos State on the proposition that slightest penetration suffices. Then for this modern position, you also see the case of Adenike versus State, Adenike versus State is 2015. 7 Nigeria Weekly Law Report, part 1458 at 237. Adenike versus State. Adenike versus State. 2015. 7 Nigeria Weekly Law Report, part 1458 at 237. On that proposition also, you see Ahmed versus Nigerian Army. Ahmed versus Nigerian Army. Hello? Hello?
Hello, sir.
Okay. Ahmed versus
Okay.
okay. Ahmed
Yeah,
versus
you,
Nigerian
sir.
Army. Okay. Ahmed versus Nigerian Army is 2016. 17 NWLR. 17 NWLR, part 1540 at 34. So we have been talking about canon knowledge, but for actus reus to be complete, the canon knowledge must be unlawful. The canon knowledge must be unlawful. So 2 elements for actus reus. There must be canon knowledge, and the canon knowledge must be unlawful. So on the unlawfulness of the canon knowledge, it simply means intercourse between parties who are not husband and wife. Intercourse between parties who are not husband and wife. Any extramarital intercourse is an unlawful canon knowledge. Any extramarital intercourse is an unlawful canon knowledge. So see section 6, paragraph 2 of the Criminal Code. See section 6, paragraph 2 of the Criminal Code. But it must be noted that the focus of the Criminal Code, the focus of the Criminal Code is on legal/Christian marriage. The focus of the Criminal Code is to accord protection for Christian and legal marriages. The old position requires corroboration for an offense of rape to be established. Under the old order, there must be corroboration. So in the case of ICO versus State, ICO is spelled IKO versus State 2011, 7 SCNJ 391. In ICO versus State 2011, 7 SCNJ 391, conviction for rape was reversed on the ground of lack of corroboration. Conviction for rape was reversed on the ground of lack of corroboration. However, the modern position is that corroboration is no longer required to prove rape. Corroboration is no longer required to prove rape. See Pokuola versus State, 2013, 7 MGSC, part 2 at 195. Where the court held that medical evidence was not compulsory as corroboration to prove rape. So for the actus reus, we are looking at lack of consent. For the actus, for the menstrual, sorry, for the menstrual of the offense of rape, we are looking at lack of consent, coupled with the knowledge that there is no consent. And it doesn't matter whether there is recklessness in ascertaining knowledge or not. So the actus reus is unlawful carnal knowledge, but the menstrual is the intention to have carnal knowledge coupled with the knowledge of lack of consent. There is intention to have carnal knowledge, and there is lack of consent, and there must be knowledge of the lack of consent. Okay? It must be noted that just like most other offenses, it is for the prosecution to prove absence of consent. It is for the prosecution to prove absence of consent. And it is not a defense for the accused to say that the victim is a prostitute. It's not a defense for the accused person to say that the victim is a prostitute or that he has been having intercourse with her before. Your father, you have been having intercourse with her before. It's not a license that you must be having intercourse with her without her consent. You can only have defense if it is a legal marriage. But if it is not a legal marriage, you are having intercourse with a prostitute. It doesn't mean that you can always be having it and rely on the previous consent. So consent is difficult to establish. And in most cases, it is by inference from the conduct of the parties. In most cases, it is by inference from the conduct of the parties. The prosecutor does not merely need to prove the actus reus, which is unlawful canon knowledge, but also it must be coupled with the knowledge of lack of consent. So there is also what we call post-penetration rape. Post-penetration rape. Post-penetration rape is a situation where the victim has earlier granted consent to the accused person, but at a point in time, she withdraws her consent, but the accused person continues the intercourse. So whatever the accused does, from the point that the victim has withdrawn her consent, amounts to what we call post-penetration rape. That is, the intercourse was initially lawful, there was consent, but at a stage, consent was withdrawn. So it becomes a post-penetration rape. So consent earlier granted can be subsequently withdrawn during the same sexual intercourse. Hence, if a lady says she does not want it again, regardless of whether the man had not ejaculated, you must desist from it. And if it continues to amount to rape, that's why the consent granted for the initial entry. And on this, you see the case of Kaitamaki versus R. Kaitamaki is spelled K-A-I-T-A-M-A-K-I versus R, 1985, AC 147.
Sorry, please, can you spell the case again, sir?
Kaitamaki is K-A-I-T-A-M-A-K-I versus R, 1985, AC 147. Still on post-penetration rape, you can also see R versus Liver. Liver is L-E-A-V-E-R. R versus Liver, L-E-A-V-E-R, 2006. EWCA CRIM, that is criminal, 278. EWCA CRIM, 278. And R also Griffs. Griffs is spelled G-R-E-A-V-E-S. That's 1999. One criminal appeal report, 319. Griffs is 1999. One criminal appeal report, 319. Okay, now we are getting close to the controversial aspects of mention of the offense of rape. Mention of the offense of rape. Now, we are talking about consent. And when there is lack of consent, then rape can be substantiated. But again, are there instances in which consent can be vitiated? When you are doing your law of contract in 200 level, I'm sure you remember. Hello?
Hello, sir.
Yes.
Sir, the system logged me out when you were actually repeating the case of Kaitamaki versus State. So the system logged. So please, I just want...
versus State is 1985.
Okay, sir.
AC 147. Then I also referred you to the cases of R versus Lever, 2006. Lever is Leaver, 2006, EWCA, CRIM, 278. And R versus Griffiths. Griffiths is GREVES, 1999, one criminal appeal report, 319. So now we are talking about vitiation of consent. To what extent can consent that appears to have been given be vitiated by one thing or the other? So I was trying to remind you of your knowledge of law of contracts in your 200 level, where they say that there can be vitiation of contracts. They give you vitiating elements like maybe fraud, misrepresentation, and so on and so forth. So also in criminal law, you know, knowledge can consent can be vitiated. Instances in which consent can be vitiated include by duress, force, intimidation, misrepresentation, threats, fear of harm, and impersonation in cases of married women or mistake. Impersonation in cases of married women or mistake. I repeat, instances in which consent can be vitiated in rape cases includes duress, force, intimidation, misrepresentation, threat, fear of harm, and impersonation in cases of married women, and of course, mistake. Now, let's take it one by one. Force. To what extent can consent be vitiated by force? So, forceful intercourse can be inferred from bruises on the victim or victim's torn underwears. Bruises on the victims or victims' torn underwear. So there's a case of Igboanugo versus State. There's a case of Igboanugo versus State. In Igboanugo and State, 1992, 3 NWLR, 1992, 3 NWLR, part 228, page 176. Igboanugo raped his schoolmate. Igboanugo raped his schoolmate. And in the process, tore her dress, bra, and pants. It was held to be a clear evidence of force. It was held to be a clear evidence of force. The court held further that the girl's eventual submission was to save her from further invasion by the boy. See also R versus Olugboja. Olugboja is 1982 QB 320. 1982 QB 320. Then we have threat. Consent can be vitiated by threat. For example, if one points a loaded gun at a woman and out of fear, she submits, she can't be said to have consented in law. If one points a loaded gun at a woman and out of fear, she submits, she cannot be said to have consented in law. On this, see the case of R versus McFall. McFall is spelled MCFALL, 1994, Criminal Law Report at page 226. McFall, is 1994 Criminal Law Report at 226. Intimidation.
Can you spell McFall?
McFall is McFall. 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 Then intimidation. Consent can also be vitiated by intimidation. And this can arise from relationships like teacher, student, employer, employee, etc. So official intimidation occurs in workplaces, and it can be in the form of blackmail. For example, threat to reveal a lady's secret, leading to her submission for sexual intercourse. Threat to reveal a lady's secret, which made her to submit for sexual intercourse. Then we have vitiation by fear of harm. Vitiation by fear of harm. An example of this is where a girl runs into a man's house because there is danger ahead, and the man accepts to accommodate her, but later threatens to expose her to the danger if she does not yield to his sexual advances. Such submission rather, is vitiated by fear of harm. Such submission is vitiated by fear of harm. Then if you look at the definition in section 357 of the Criminal Code, it talks about a situation where somebody misrepresents the husband of a married woman and the woman submits. That consent is also vitiated. So impersonation. So representation that involves impersonation of another person can vitiate consent. For example, consent expressed by a woman to a man who impersonates her husband is vitiated. However, it does not extend to physical, it does not extend to impersonation about physical conditions, like whether a man has STD or socio-economic status. Socio-economic status, maybe from somebody who wants to woo a girl and tells the girl that he's the son of Dangote, whereas he's the son of a very poor peasant farmer in the village. So because he says he's the son of Dangote, the lady submits and the sexual intercourse takes place, only for the lady to know later that the boy is from a very poor background. The position of the law is that that does not amount to rape. That impersonation does not amount to rape. So it must be impersonation as to the identity. That is husband and wife, for example. Impersonating the husband of a woman. So now, Section 4 of the Criminal Law Act 1885. Section 4 of Criminal Law Act of 1885 is to the effect that impersonation as to social status or maybe STD status does not amount to rape. So are there defenses? Are there defenses to the offense of rape? Yes, there are. There are instances in which an accused person charged with rape can put up a defense to rape, to the offense. And we are going to look at two defenses. The first defense is that of mistake, and later we'll look at intoxication. So because sometimes when we give you hypothetical cases, we also put likely defenses there. So it is for you to identify that and discuss it. So for mistake, the mistaken belief must be reasonable.
Excuse me, sir. I have a question, sir. Sorry to interrupt you, sir. I wanted to ask, what is the position of the courts with regards to a situation where the victim of, like, somebody who is suffering from Stockholm syndrome? Stockholm syndrome occurs in cases where there's a psychological response in which a hostage or abuse victim develops positive feelings towards their captor. So I want to know the position of the court with regards to that, where there is a kind of or there is a kind of relationship that occurred between the victim and the perpetrator. I want to know the position of the law, sir.
Well, I wouldn't know the kind of syndrome you are talking about, but the one that I know very well, we usually examine students often, is when the victim has Down syndrome. Down syndrome is a situation maybe when the victim is suffering from either idiocy, or maybe is imbecilic, or has some kind of, personality disorders and so on, and which does not make that victim capable of expressing a valid consent. So in that kind of situation, it will be treated as defilement, and the punishment that is applicable to defilement will be meted to the accused person. Because it is not a defense that she didn't resist, she consented. But the mere fact that she's a Down syndrome patient shows that such consent are not valid in law.
Please, I have a question.
Yes.
On intimidation, I want to understand the scope of intimidation. Does it only manifest in workplaces?
Yes, it does. It does. For example, let's say a lady is working in the bank, and maybe she bedwets. When we say somebody bedwets, but it's a secret that is known to her alone. Then you are a colleague to the lady as a man, and you have privileged information of that kind of stigma. Then you visit the lady one day and you want to make sexual advances to her, and she resists. That, look, we are not dating, and you can't just take advantage of me and so on. And you now tell her that, look, you know that if you don't succumb, if you get to the office tomorrow, maybe it's a Sunday, say on Monday, everybody in the bank, I'm going to reveal your secret that you bedwet. So in that kind of situation, the lady who doesn't want people to know about her situation now submits to that sexual advance. That is the example of intimidation.
Yeah, yes, sir. What I'm curious about is, can it take place outside the workplace if someone that she's not working with threatens her with information that the person has about her?
Yes, of course, it can happen outside the workplace. Intimidation is anything that can, maybe something that can result in blackmail. That kind of a thing, and you just don't want it to happen, and you succumb. So the consent is not voluntary. So we are not talking about mistake now. And so in the case of DPP versus Morgan, 1975, 12 All England Report 347, DPP and Morgan is 1975, 12 All England Report at 347. The defendant and others had intercourse with the woman. The defendant and others had intercourse with the woman on the invitation of the husband. On the invitation of the husband, who told them to ignore it if she puts up resistance. In fact, the husband told the rapist that he invited that if the woman shouts or cries, that is when she starts enjoying sex, that they should not mind. That if she's crying or she's shouting, that it should continue. That is the evidence that she's enjoying the intercourse. So he told them to ignore it if she puts up resistance. And the court held that belief in consent was unreasonable. So the accused person were trying to put up a defense that, based on what the husband said, by the time she was putting up resistance, they assumed that she was consenting. And the court held that such belief was unreasonable, and that the defense of mistake will not avail them. So constant mistaken belief must, be reasonable. So it was held that if the accused was having a mistaken belief that the victim was consenting, he will be absolved of rape, provided that belief is reasonable. However, this decision was modified in the UK in a subsequent statute in 1976 because of the potential danger. So the impact of the Sexual Offences Amendment Act 1976 is that the actual knowledge of lack of consent was distinguished from accused recklessness to ascertain consent. So the modification is to the effect that the law is not really interested in actual knowing that the victim actually consented, but the law is interested in whether the accused was reckless to ascertain consent or not. So in the case of R versus McFall, Supra, in R versus McFall, Supra, the girl feigned orgasm. She feigned orgasm, that is to pretend. She feigned orgasm throughout because she thought that her former boyfriend will shoot her if she doesn't cooperate in the hotel. She feigned orgasm throughout because she felt the boy will shoot her if she doesn't cooperate. It was held that the former boyfriend was guilty of rape, as there was no consent. It was held that there was no consent.
The case again.
R versus McFall. I've earlier cited. That's why I said Supra.
Okay.
The girl feigned orgasm throughout because she thought her former boyfriend would shoot her if she doesn't cooperate in the hotel. It was held that the former boyfriend was guilty of rape because there was no valid consent. You should also note that a sleeping partner cannot express a valid consent. A sleeping partner cannot express a valid consent. And that mere non-resistance or submission does not amount to consent. Mere non-resistance does not amount to consent. So in R versus Latta is spelled L-A-R-T-E-R. R versus Latta, 1995, Criminal Law Report at page 75. It was held that it was rape to have intercourse with a 14-year-old who appeared to be sleeping throughout the episode. It was held that it was rape to have intercourse with a 14-year-old who appeared to be sleeping throughout the episode. Also in R versus Meyers, because I was telling you that we are going to look at defense of mistake and intoxication. So on the defense of intoxication now, you know that generally the rule is that it is only involuntary intoxication that can avail you. If intoxication is voluntary, it doesn't avail you. So in R versus Meyers, 1873, 12 Cox Criminal, 311. 12 Cox Criminal Code 311. An accused person charged with rape. An accused person, Meyers is also on mistake. A sleeping partner. Meyers is also on sleeping partner. So for intoxication is R versus Mahon. R versus Mahon. On intoxication is R versus Mahon. 1998. EWCA criminal 1462. In that case, defendant had intercourse with the victim in an intoxicated state, and it was held to be rape. Defendant had intercourse with the victim in an intoxicated state, it was held to be rape. So what we are saying here is that an accused person charged with rape also pleads defense of intoxication pursuant to Section 29 of the Criminal Code. However, it must be noted that voluntary intoxication does not ordinarily avail an accused person. But what if you have intercourse with an intoxicated victim? Because these are two different cases. if you yourself is intoxicated and you have sexual intercourse without consent, it does not avail you. But what if you have intercourse with an intoxicated victim, which is a different case? And that's what happened in R versus Mahon. D had intercourse with V in intoxicated state. It was held to be rape because an intoxicated person cannot give consent. Okay, now, we also want to interrogate consent that is not related to the nature of the act. And this is also very important when it comes to examination purposes. Consent that is not relating to the nature of the act. For example, where a girl consents to a particular act and the accused resorts to sexual act in the course of that, it shall amount to rape. So we are looking at two very important cases here. The case of R versus Williams, very popular case, 1923, 1 KB 340. This was a case where a teacher told one of his female students, a 16-year-old girl, that he wanted to carry out an operation on her, and that the said operation was to develop her voice so much that she would become a star singer. The accused resorted to having sexual intercourse. The pupil actually submitted herself, thinking genuinely that the accused person wanted to do some operation that will improve her voice. So after succumbing, the accused resorted to having sexual intercourse, rather, with the pupil in the process. It was held to be rape. Then we also have the case of R versus Flattery, 1877, 2 QB D 410. R and Flattery is 1877, 2 QB D 410, where the defendant was convicted for rape, having induced the victim to submit to intercourse by deceiving her that he was performing a surgical operation. The deceiver that was performing a surgical operation. So she succumbed, submitted herself, only for the accused person to have sexual intercourse with her. So there are cases where the accused person spent counterfeit money for prostitutes, or where there's misrepresentation about HIV status. Misrepresentation about HIV status. So in the case of R versus Dicker, 2014, Dicker is DICA, 2014, EWCA criminal 1103. It was held that the concealment of the accused HIV status was not as to the nature of the sexual act itself, but to the risk of infection. So it will not amount to rape. If for example, you are my girlfriend, and you ask me about my HIV status, and I said, oh, negative. Trust me, it's negative. Then you succumb to sexual intercourse. And at the end of the day, you later discover that I'm HIV positive. The position here is that it will not amount to rape because it is not a misrepresentation as to the sexual act. We also have the case of Asange versus Swedish Prosecution Authority. Asange is AWSANGE versus Swedish Prosecution Authority. 2011, EWHC 2849. It has to do with the use of condom. It has to do with the use of condom. I think the accused person in that case.
Sorry, please, sir, can you help us repeat the citation, sir?
The citation is 2011, EWHC 2849. EWHC 2849. They both agreed that the accused person will use condom. But the accused person used condom, and sometimes along the line, remove the condom and, was doing it flesh to flesh. And the victim said that was not our agreement. You are trying to endanger my life. It will amount to rape, and the court held that it will not be rape. Also in R versus Lineker, Lineker is spelled Lineker. 1995, 2 criminal appeal reports at 49. 1995, 2 criminal appeal report at 49. It was held that failure to pay £25, which the accused person promised a prostitute after intercourse, was not rape. Failure to pay £25, which the accused person promised to pay the prostitute after intercourse, was held not to be rape. It must be noted that attempted rape is contained in Section 359 of the Criminal Code, and it is punishable with 14 years imprisonment. While rape simpliciter, as contained in Section 357, is punishable with life imprisonment. So we may have to pause here because I want to go and catch a flight now. I have an official assignment in Abuja. So next class, I think on Tuesday, we should finish because I only have left indecent assault and defilement with you. And I'm aware that the revised timetable, exam timetable is out, and your exam should be starting 300 level, should be starting maybe from 24th. And I do know that like a week to exam, your lectures are supposed to stop so that you can have 1 week revision and so on and so forth. So I think we are still covered for next week, after which there shouldn't be lectures again. I want to wish you that you enjoy the rest of your day. So we have concluded rape. So we have indecent assault on female and defilement left to cover. So if I have any question, otherwise we'll call it a day.
Sir, sorry, sir.
Yeah.
Please, do you, I want to get the spelling of R versus Mahon, the Mahon there.
R versus
Mahon.
Did I say something like Mahon? Mahone.
Okay, thank you, ma'am. Thanks, sir.
Mahone. Mahone.
Sir, please.
Yes.
I did not get the explanation on corroboration, sir.
Huh?
The explanation on corroboration, sir.
Yes, I said the old position of the law of rape is that corroboration is required. Okay, but the modern position is that corroboration is no longer required. So in Iko versus State, the conviction for rape was reversed on the ground that there was no corroboration. And I said the modern position was as stated in Popola versus State, where the court held that medical evidence in corroboration for the offense of rape was not compulsory to prove rape. Are you clear now?
Not so clear, sir.
The old position was expressed in Iko versus State, but the modern position on corroboration was expressed in Popola versus State. That corroboration is not necessary, is not compulsory again to establish the offense of rape.
Good afternoon, sir. I have a question.
Yeah.
So, when you're talking about consent, vitiating consent, defenses, you mentioned mistake. So I would like to ask if for defenses, sir.
Mistake, then intoxication.
Yes, sir. So I would like to ask if the mistake is as to the consent alone, because there was this past question that I saw where the man had intercourse with the lady, thinking that the lady was his wife, and at the end it was like he thought that the woman was his wife, and she didn't also maybe resist, since he does not have the same stature with with her husband rather. So I'd like to know if that defense can avail him there. Plus, in that question, the lady was actually sleeping in the dark when the man came.
Yes, the question you are talking about has to do with two people going to a hotel to stay over the night, and both of them left their wives in the hotel rooms that are close to each other with different numbers. So they went to the bar. So there was this one that left the bar first, and who had taken some bottles of beer. We put it there. And we have the reason for saying that. So when he got to his own room, when he got to the two rooms are beside each other. His own is not the next one. The other man that is left in the bar is the first one. So he got to the first one thinking that it is his own room. So he opened the door. It was not locked with key, but it was jammed. He just opened it. And the wife of the other man was already lying down on the bed, expecting her husband. And this man just entered. And the woman assumed that it was her husband that entered. So without saying anything, if he had talked, maybe he would have noted that this is not my husband's voice. He didn't just talk. He assumed that it's his wife as well. Just undressed and slept beside the woman without saying anything. They had a foreplay, no talk, nothing. Then they had intercourse. I think midway into the intercourse, it's done on the woman that this is not my husband. Then he pushed the man away. So the case was reported, and the man was charged with rape. Then he put up the defense. Then we said the case was reported anyway. So we are now trying to ask you students what the likely defenses are available for the accused person. So in this kind of situation, we told you you took bottles of beer. That's enough to raise the defense of intoxication. But the question is whether it was voluntary or involuntary. So you know the answer. Then concerning the issue of mistake, you can also put it up. But whether the mistake was reasonable or not, it's a different ballgame. From the scenario of the case that was given to you, it's very easy for somebody to make a mistake of entering a wrong room. It happens. Especially when it is not that you are using key to enter. It's just jam. Just open the door and it opens. And you enter. No discussion, no talk. And there was switch off the lights, like you have said. So you assume it's my wife, and the woman also assume it's her husband. So you can't even say that it is a case of impersonating somebody's husband. He wasn't impersonating. Wasn't impersonating. He assumed, in all honesty to him, that this is my wife, this is my room. So are you getting the point now? Hello?
Yes, sir. Yes, I get it, sir.
So it's straightforward. There's been
So what about the fact that she was sleeping?
Yeah? Sleeping?
The fact that she was actually sleeping when the act happened.
No, she was not sleeping. We won't put it there that she was sleeping. She was lying down, expecting her husband.
Sir, you put it there. You said got into the bed with Juliet, who was sleeping in the dark.
Oh, no. Look at the question very well. Oh. The one that I said.
I'm reading the question.
She was lying down on the bed, expecting her husband, but the light was switched off. And when the man entered,
okay, I've seen your own question.
She actually saw the man entering. It's not as if she was sleeping and she didn't know when the man came or whatever. No. That one, the issue of mistake may not avail the man if the woman was sleeping. But she also assumed that it was her husband. So there was consent, no resistance. But it was vitiated by mistake. Okay, are you getting it now? Yes.
Yes, sir.
So in the absence of any other question, then we call it a day.
Sir, I have a question.
Okay.
Hello, sir, I have a question.
Okay, that will be. I'm taking one more question because I want to go and catch my flight. So I'll take one more question.
Sir. Hello, sir.
Yeah.
So I just wanted to ask.
Question, you can reserve it till next class at one side. Yes.
So I wanted to ask about a situation whereby, like, you talk about the defense of intoxication and that an intoxicated person cannot give consent, and that someone and the defense of intoxication will not avail someone who is voluntarily intoxicated. So my question is, what happens when the two parties are voluntarily intoxicated? Like, if say a man and a woman were drinking together and then eventually they had sex and the woman like does not, like, in the course of them having sex, the woman never gave consent, but like both of them were drunk. So what happens?
You know, we are looking at the liability of the man. We are not looking at the liability of the woman. So the man, whether the woman is drunk or not, is in the state that she was, can she give valid consent? The answer is no. So that takes care of that her own side. But for the man now, her intoxication was voluntary, so it will not avail him. So he's guilty of rape. Because the consent given by an intoxicated woman, whether she was voluntarily intoxicated or not, is no consent.
Okay, sir. Thank you, sir.
Yeah. Okay, gentlemen and ladies. See you on Tuesday by the grace of God. Bye.
Bye. Thank you, sir.
Bye. All right.
Bye, sir.
Okay, bye-bye. Okay, bye-bye.
Bye, sir. Thank you very much, sir.
I forgot that. Koja time. Koja time.
We hope you make your flight, sir.
Thank you.
Kilishi, sir.
Sir, if you are still there, I want to ask this question off record, sir. Hello, sir, if you are still there.